Thanks, Rana. Hi, everyone. I'm Scott Bruton. I'm the Senior Vice President for Housing Policy Research and Development at the Coalition for Nonprofit Housing and Economic Development. Whew, okay, too many words. Thank you very much for joining us to talk about, or to listen to the presentation about this very important topic today. The National Housing Trust, through their National Preservation Working Group, has been following the issue of low-income housing tax credit right of refusal challenges and threats at year 15 since at least 2016. CNHED engaged with the National Housing Trust a little over a year ago to find out how we could collaborate with their national efforts to see if we could bring some protections to LIHTC existing and new LIHTC projects here in the District of Columbia. And out of that collaboration, thankfully, came some very positive results in the most recent qualified allocation plan, as well as the most recent consolidated request for proposals, which we hope will benefit us in the years forward. So I would like to introduce Moha Thakur, the Public Policy Manager at the National Housing Trust. Moha is going to be our moderator for the panel today. She'll take care of introducing the panelists and managing the flow of the panel, as well as the Q&A at the end. And again, thank you very much to Moha for being our partner in this work for over the past year, and for all of the NHT's work on this over the past several years. Look forward to listening to the panel. I hope you all enjoy.
Thanks, Scott, and thanks for the introduction. And thank you all for joining today. As Scott mentioned, my name is Moha Thakur, and I'm the Public Policy Manager at the National Housing Trust. I'm joined today by my colleague, Bobby Rosen, who's a policy attorney, who actually helped to draft the original Housing Credit Program policy provisions, Aaron O'Toole from Klein Hornig, and Hank Brothers of the Law Office of Hank Brothers. And so today we're just going to be giving you an overview of what is the right of first refusal that is within the Housing Credit Program, as well as talk to you a little bit about what we're seeing across the country in terms of litigation, the landscape, as well as some recommendations on what both allocating agencies can be doing and what we've worked towards here in DC around the changes that Scott mentioned. So I'm going to share my screen with this PowerPoint. So those of you who are unfamiliar with the National Housing Trust, I'll just give you guys a brief summary. We're a national nonprofit organization dedicated to creating and preserving affordable housing. We provide opportunity, advance racial equity, strengthen community resilience through practice and policy. We have our policy advocacy arm, as well as doing real estate development, lending, and energy solutions. We not only work on federal policy, but also have been working closely with state and local housing agencies for many decades now, engaging on state and local housing policies, as well as the Housing Credit Program. So I'm excited to welcome you all and my fellow panelists to what is going to be a pretty packed agenda about protecting affordable housing communities through the right of first refusal. As Scott mentioned earlier, NHT has been working with our state and local jurisdictional partners for a number of years on this topic, and we're really excited by the momentum that we're seeing nationwide. A lot more agencies are realizing the role that they can play in protecting this right and are taking action, including the District of Columbia that incorporated some of our recommendations into their recent QAP and RFP. What I think you'll find that all of the panelists today, including myself, will try to impress upon you is that many of these disputes that we're seeing around the right of first refusal is happening more and more. And while only a small number of them are escalated to the level of litigation, either here in DC or elsewhere around the country, that in no way means that developers or policymakers should be sitting idly by until we see these widespread activities happening. So I will be starting with a little bit of background on what is the right of first refusal, the kinds of disputes we are seeing and their impacts for those of you who are unfamiliar. My esteemed legal colleagues will be able to share more on the industry-wide perspectives on these non-preservation minded investors, some red flags that developers should be aware of, as well as some best practices. And we're hoping to also be able to share with you some of the case studies of where we've seen these disputes happening from the metropolitan DC area. As many of you already may know, the Housing Credit Program is one of the largest federal affordable housing programs, and it facilitates the partnership between developers and investors. So these investors are seeking to benefit from federal tax credits in return from developers who are seeking support for the creation and preservation of affordable housing. So at a minimum, the state or local allocating agencies require 15 years of compliance and then 15 years of extended use. Though obviously we do see some states require up to 60 years or even perpetual affordability. For deals that involve both nonprofit and for-profit general partners, the limited investor or limited partner is usually expected to exit this partnership at the end of the compliance period, either at or around year 15. In 1989, Congress actually amended the original Housing Credit Program to permit partnership agreements between property owners to give nonprofits the right of first refusal, or what we call a ROFA, to obtain full ownership of affordable housing properties after year 15. Congress took this action to encourage ownership by nonprofits for the purpose of maintaining rent affordability restrictions into perpetuity. This statutory right of first refusal, which is laid out in Section 42I7 of the Internal Revenue Code, permits nonprofit developers, as well as in some circumstances, government agencies or tenant groups, like here in DC, we have TOPA, a right of first refusal that allows them to obtain that full ownership of a property at a minimum purchase price by assuming the debt on the property and paying any exit taxes owed by the investor. This, of course, would happen once the investor has claimed all of the housing credits, though before the programs and the property's rent restrictions expire. On the for-profit side, the general partner similarly has an opportunity to acquire the property and purchase the property at fair market value, or purchase the limited partner's interest in the partnership at that exit around year 15. So one thing I will just say is, for most of the program's history, with both for-profit and non-profit developers, we have seen that the limited investor partner usually does exit the partnership at the end of the 15-year compliance period as expected. We see this sort of as business as usual, which allows the general partner then to obtain full ownership and continue to maintain property as affordable in line with their mission. However, in the last, I would say, 10 or so years, we've seen more and more troubling actions across the housing credit industry as outside capital sources are buying up control of these housing credit investor limited partnerships, with the express goal of extracting resources out of affordable housing properties after that initial 15-year compliance period. And so this rapidly growing phenomena is catching many affordable housing advocates, stakeholders, and policymakers unaware. And we believe it's going to have and has had a profound impact on the state of affordable housing in this country. Essentially what we're seeing is these major sources of outside capital have discovered this sort of commercial sector to exploit and reap hundreds of millions of dollars of profits from these housing credit developments, which is contrary to the original intention of Congress. And so these outside capital firms that we call aggregators, I will say, are most importantly not often the entities that were a part of the original partnership with the developer, but those that have since bought up the investor limited partnerships after the tax credits have been claimed, with that purpose of getting these returns from residual value. Their growing impact, I would say, for all of us on this panel and many others, has us concerned that some of these initial investors may also be seeing these high returns that could be gained from being a part of these partnership deals and follow in the footsteps of these aggregators and extract resources out of affordable housing communities. So this pattern, as I mentioned earlier, has sort of led to this growing number of legal disputes and litigation that both drains the general partner's resources through this litigation process, as well as threatening the long-term affordability of these valuable affordable homes. We've seen challenges to these general partners' project transfer rights that involve both the nonprofit side, so the nonprofit right of first refusal, as well as the for-profit side, so the for-profit purchase option. So most often on the nonprofit side, first of all, these aggregators often take the position that Section 42I7, the ROFA that is in that statute, is in fact a common law right of first refusal, which it is actually not, and that they are not required to recognize these rights that are established from the partnership agreement without a third-party bona fide offer. So they're essentially taking the view that this contractual language that is in the original partnership is basically meaningless. On the for-profit side, we are seeing these disputes take the form of disputing what is the fair market valuation, demanding a payoff of positive capital accounts, or insisting on allocations based on the liquidation of partnerships. So in some cases, what we've seen is this limited partner may actually force the property through a qualified contract process, ending the affordability restrictions entirely. So recognizing that most general partners, particularly nonprofits, don't have these resources to litigate contractual issues in court for many years. These private investors or aggregators are instead leveraging a profitable cash payment or the sale of the property in return for leaving this partnership. And this clearly undermines the long-term viability of affordable housing properties, the original intent of the housing credit program, and leaves these properties at risk for leaving the affordable housing market, whether or not there's an actual sale of the property. I think also the use of these scarce funds for paying off general partners, the use of these funds from general partners to paying off private investors is totally contrary to the original intent of the housing credit program. And I think that rising values in certain markets has created this opportunity for these firms to profit far beyond original investor expectations. So I'll also say from a more mission-driven perspective, this detrimental process is also diverting resources that would otherwise be devoted to resident services or building maintenance or related affordable housing opportunities. I know as a nonprofit, NHT, we not only are investing in the physical housing for our residents, but also supportive services, education and training programs, partnership with other local organizations that would benefit community members and maybe not just our residents. I think further when investors are extracting these resources from a mission-driven nonprofit that's dedicated to serving these disadvantaged members of a community, those resources are then often shifting from maybe a community of color to a privileged white investor in an outside area. So I think there are just this huge number of detrimental effects that we've seen this process have on nonprofits and for-profits who are committed to providing a community with affordable housing. And I think without sufficient reserves or financing, because that money is going towards legal fees or the aggregator directly to remove them from this partnership, mission-driven developers may be unable to maintain low rents, provide these wraparound services, and just ensure that these properties are maintained as high-quality housing. Again, as I said, without these reserves, with these payoffs, we've seen have had to exit the affordable housing market. But what I will say, because I don't want to end on such a negative note, is thankfully we do have these valuable partnerships. My panelists with CNHED and other partnerships across the country, many allocating agencies who are involved in the housing credit program are all working to help mitigate these threats and ensure that there is long-term preservation for affordable housing. And so with that sort of background, I will now pass it over to Bobby, who'll discuss the state of the industry and some best practices.
Thank you, Moha, and thank you for this opportunity to talk to people today about this issue. We're seeing as Moha said, a very rapid growth of these type of activities across the country by aggregators and other investors. Litigation in federal and state courts against general partners and state housing finance agencies. I've counted more than 40 lawsuits, and if there are more than 40 cases in litigation, it means that there are, scores and scores, hundreds maybe, of legal disputes involving investors who are challenging the contract that the partnership agreement in these deals. They're also have engaged numerous law firms to lobby Congress against federal legislation that has been introduced to address this issue. And they've been very active publishing articles critical of nonprofit rights in industry journals. I do these webinars quite a bit, and one company in particular, Alden Torch, likes to, I guess, troll us and participate or sign up for these webinars. And I see that somebody from Alden Torch has already started putting things in the chat line that raise questions about our presentation today. Next slide, please. Industry trends. So we're seeing increased activity. These aggregators who are acquiring control or they're acquiring an interest in funds or in property partnerships. This is a real growth area because they're making a tremendous amount of money. And others see what's going on. Private equity is attracted into this space. Traditional syndicators and investors see what can be done by squeezing general partners after year 15. And this is causing a change generally in industry behavior. That's why we're trying to get out there and educate nonprofits and for-profit general partners about what's going on, and particularly trying to educate housing finance agencies, because a lot of this activity is not apparent. When a property partnership is involved in a legal dispute, maybe that doesn't rise to the level of litigation, it's generally something that doesn't come to the attention of other nonprofits in the state or the housing finance agencies. The latest trend seems to be, so far, most of the litigation has involved property general partners. And we've seen one aggregator who has been involved in 2 lawsuits, at least that I'm aware of, against an upper tier general partner, which is a new thing, trying to force and intimidate the upper tier general partner into doing the bidding of an aggregator who has maybe taken an interest, an LP interest in the upper tier fund. And as I said, as these aggregators reap large rewards, other syndicators or traditional syndicators and even direct investors are looking, well, maybe I can get residual value. Maybe I can make it difficult for the general partner, whether it be a for-profit deal or a nonprofit deal, and demand some extra payments to exit the partnership. And as I said, the emergence of private equity is real concern. They have seen that this is a way to make money. Blackstone, the largest private equity company in the world, recently bought Sun America. Sun America has been involved in litigation all across the country with general partners. Next slide, please. So if you are a general partner in an existing deal, there are some red flags that you should be aware of. If the investor LP interests have changed hands, that should raise alarms in your mind. If the LP's interests are managed or affiliated with organizations that have been involved in a lot of litigation in this area, be concerned. For-profit GPs, where there's a large positive capital count, you can look and expect that the investor is going to demand to monetize that through the cash out process, and maybe also claim that there has to be a liquidation of the partnership, which has a different waterfall and share of proceeds. If the investor begins to talk about future planning, future values and circumstances beyond year 15, like refinancing or re-syndication, that re-syndication or refinancing can be a means to buy them out to pay them off basically in excess of what you expected via the partnership agreement. If they start to say, claim that there's a restriction on the use of reserve accounts and that they need to get approval of it, that might indicate that they want to claim on that reserve account when they leave the partnership. Qualified contracts, that's something that where it's available, they demand that you go through the qualified contract process. And what that leads to is the loss of affordable housing after 15 years. Or maybe your exit negotiations are stalled. They just hold on and they're non-responsive. They're non-responsive because the longer they hold on, it gives them leverage against the general partner. Or a common thing is that the investor LP will question routine financial reports. In many, if not most of these deals, what they end up doing, whether it's just at the legal dispute area or the point, or if it's actually in litigation, is that they will claim the general partner breached its fiduciary duty. Why do they do that? Because if that is actually the case, the general partner can lose their property. They're kicked out. And even if it's not true whatsoever, it gives them a huge amount of leverage to claim breach of fiduciary duty because you turned in a late financial report, or there was a mistake, or you didn't charge high enough rents up to the regulatory agreement maximum. If you're not adequately familiar with your documents and you're starting to and talking to and if you're fielding questions from your investor about their exit, that might be a reason for alarm as well. Next slide. So HFAs across the country are starting to be attuned to what's going on with their, I consider housing credit properties assets of the state, affordable housing assets, huge shortage of affordable housing assets. And the industry, and certainly the HFAs who run these programs, really cannot afford to let these assets be attacked by outside capital who's demanding payments of money that will undermine the GP, undermine the nonprofit, undermine the property. So agencies are beginning to require review of any sales or transfers of investor interests and refusing to honor it if it's going to these aggregators. And HFAs are beginning, I think we have a long way to go here, to understand the scope of this problem and make sure make sure developers and general partners understand their ROFR rights. Really, agencies ought to be very active in working with nonprofits and their affiliate general partners for them to understand these issues, to protect their rights. Next slide, please. And with regard to new allocations, that last slide applied to existing properties. For new allocations, HFAs are starting to amend their QAPs. A number of states have done it already. A number are considering it, to exclude any equity provider which has sought an early termination of housing credit extended use agreement. That would be through the qualified contract process, or refused to recognize a nonprofit ROFR, or otherwise undermine long-term affordability of the property. Very important that this activity go on and that states be keyed into this and to protect their nonprofits and for-profit developers. And then states are starting to require that ROFR agreements include certain features to protect the rights of nonprofit sponsors, so that they make sure the ROFR is drafted correctly to maximize protection. There's a lot of ROFRs out there. There's been an evolution of how they're drafted over the years, and they can be drafted to provide a lot better protection. Thank you.
Thanks, Bobby. So we thought we'd maybe briefly walk through the few changes that we want to highlight in the 2021 DCQAP. And much of this language is very similar to what is in the consolidated RFP as well. So as Scott mentioned at the beginning of this presentation, Last year, NHT, along with CNHED, Wesley Housing, and of course, my invaluable colleagues on this panel, worked pretty closely with the DC Department of Housing and Community Development. They were anyway going through an update of their QAP, and we wanted to ensure that there were some of these important provisions that Bobby just spoke about that were included. And we were very pleased to see that this revised QAP that came out last year has included a number of these additional requirements, specifically around the right of first refusal. So I want to highlight these 5 sort of updates to the language, and we'll also turn it over briefly to Aaron, who's going to sort of discuss these implications and what they mean for partnership agreements and sort of doing deals in DC. So first, I will say, so DC now requires credit applicants to include an investor letter of intent that includes written acknowledgement that the investor has never sought to achieve early termination of a LIHTC extended use agreement, either through the qualified contract process or have sought to undermine an exercise of the right of first refusal or the nonprofit's option to purchase in prior transactions. So we think that really sort of covers what we or promotes what we like to call sort of more a preservation-minded investor, one that is really supporting mission-driven nonprofits and for-profits. The QAP also clarifies certain aspects of the nonprofit right of first refusal, such as the consent of an investor to the right to exercise a ROFR, the fact that this ROFR does not need to be conditioned upon receipt of a bona fide third-party offer, and as I mentioned earlier, that this ROFR is not the same as a right of first refusal under statutory, court interpreted, or common law. The QAP also states that the ROFR must be exercisable for a period of at least 24 months following the end of this compliance period, and must allow at least 12 months to close following this exercise, which we believe gives a mission-driven owner sufficient time to sort of exercise its right of first refusal and sort of go through that process. The QAP also clarifies that the exit price cannot exceed debt plus taxes, plus amounts that are owed to the investor as determined by the project accountants. And I'll say while we strongly support these new provisions, I know at least from NHT, we continue to urge DHCD to sort of move these provisions to a threshold eligibility requirement. We've seen many states sort of start off having these requirements sort of as points or incentives, or here in DC as part of the evaluation criteria. But we really want to make sure that these provisions apply to all housing credit deals that are happening in the District of Columbia and aren't outweighed by any other sort of evaluation criteria. So Aaron, I'll now pass it to you, I guess, to briefly discuss some of these implications.
Yeah, thanks, Moha. And thanks everybody for listening in today. Just to emphasize that last point, I mean, most of these elements relate to the additional points available for certain nonprofit projects under the DC QAP and the recent NOFA. So, and it's also important to keep in mind that for the most part, these elements that have been added to the DC QAP and in other jurisdictions are largely prospective, right? They're dictating what needs to be included in ROFRs for deals that are happening now. They can't write language into ROFRs for old deals. The first element is the one that's a bit both forward and backward looking in terms of requiring the investor to certify that they haven't attempted to frustrate a ROFR. That's designed to encourage investors to be to honor those ROFRs and be good actors, so that they don't undermine their ability to continue participating in deals. The strength of that is unfortunately a little bit weakened by the fact that many of the folks that do challenge the exercise of ROFRs are not ones that are originating new deals. They're buying existing deals and coming in. But every little bit helps, and it's important that the HFAs are coming at this from as many angles as possible. Let me highlight maybe one of these points that Moha flagged here, which is on the last one, the calculation of the purchase price under the ROFR. You'll note that it does have one element that's not in 42I7, but is quite common in most negotiated ROFRs, which is other amounts owed to the investor under the partnership agreement. And that, I think that's generally considered reasonable, if an investor has made an advance to cover deficits, or if there was a tax credit adjuster that they were never repaid, that they have the ability to recover that at the time of exit. But it does not allow for, additional amounts on top of that, which are sometimes seen, including in situations where there might be a joint venture of a nonprofit and for-profit developer, for example, where there's some additional amount paid by the nonprofit as part of the exit. And the other important element here is that that determination is put in the hands of a project accountant, a third party. And both of those elements are going to kind of come up in case studies that we're going to talk about soon. So I think that's kind of what I wanted to highlight here. Moha, thanks.
Bobby, did you want to cover the federal legislation?
Yes, so as we've been working on this issue of educating the development community and educating housing finance agencies about steps that can be taken to protect their interests. We've also been working with Congress on legislation that would clarify current law, and on future deals would change the right of first refusal to a purchase option that would be realized, it could be realized as a safe harbor. It doesn't have to be in these deals. It doesn't have to conform to the language of the federal statute. It could be less than that, but it would permit future purchase options for future deals that could be realized just by assuming the debt on the property. No requirement to also pay the exit taxes of the investors. It would clarify current law, that the current law, when it refers to property, includes all assets of the partnership, not just the real estate. Clarify that investor consent is not required to exercise the ROFR. It would clarify that the exercise of the ROFR does not require a bona fide offer, and any entity, including a related party, may make an offer. This is what the litigation across the country has been focused on. The aggregators make a claim that regardless of what the agreement provides for, if the agreement is silent or simply refers to the 42I7 safe harbor, they are going around and they're asking courts and they're demanding of general partners that to exercise the ROFR, you have to have a bona fide offer from a third party. And what is a bona fide offer? Well, that is also subject to legal dispute, and different courts have said different things about that. So this legislation says, well, we're going to clarify that. We're going to clarify it to conform with the original intent of Congress when this was written in 1989. Another element says that the ROFR may be exercised through a purchase of the partnership interests as well as a transfer of property. Generally, when the transfer occurs, that's the way it occurs. That's the way it happens, although there's a difference of opinion as what the meaning of the statute is. The change proposed at the federal level says that these clarifications would not supersede express language in current agreements. It clarifies ambiguous language. And that's important because the aggregators have taken advantage of this ambiguity in the meaning of the law and the partnership agreements. And they have challenged the interpretation that the general partner has, either in court or in legal disputes, And because they're very large, wealthy institutions that are involved in litigation all across the country, it gives them tremendous leverage to get their point of view across, either forcing the general partner to succumb to their point of view or getting a court, or at least bringing it to litigation. Remember, general partners are not in the business of litigation. Nonprofit developers don't want to be in litigation. It's extremely costly. But this is the business of aggregators. They're in litigation all over the country, and they use that. They use their huge asymmetry of resources to intimidate general partners, for-profit and nonprofit, forcing them to make a payment or to go to court and waste hundreds of thousands of dollars defending themselves. So that's why this legislation is so important. It was in Build Back Better, the House version, the Senate version. I don't know what's going to happen with it. If that legislation doesn't pass, I don't think we're going to enact federal legislation, because the aggregators have hired scores of lobbyists. They're spending millions of dollars a year on lobbyists. And they've convinced a number of members on the Republican side of the aisle that this is not fair to them to clarify the law to protect nonprofit developers.
Thanks, Bobby. And I'll just add as well that we've seen a number of HFAs around the country actually include additional language in their QAPs or other sort of policy documents that explicitly state that if there is a change to the right of first refusal through the federal legislative process, that the right of first refusal would also sort of change along with that and would not sort of supersede that federal legislation, which is definitely a positive step in the right direction. And so I'm now going to pass it over to Hank, and then afterwards to Aaron as well. Bobby and I have sort of been talking a lot about sort of the policy, the industry, the landscape, but we thought, especially here in DC or the DC metro area, might be helpful to have some case studies to show where this has already happened and is continuing to happen in the city. So Hank, I'll pass it over to you.
Thank you all. Just by way of introduction, I've been in practice for over 35 years in DC, as well as, in DC, but with a practice that has been nationwide. From the outset, I was involved in affordable housing matters in multiple roles: lender rep, investor rep, owner rep, and as well as other roles that can arise in these deals. And I've been involved in tax credit deals, since 1987, when the 86 Tax Act took effect. And in fact, I've been involved in the property that I'm featuring here for about that long as well, in various iterations. It is a profit-motivated general partner. The general partner has owned interest in this property since the early 1970s. The current situation is a tax credit partnership that was entered into about 20 years ago. Property was placed in service for that in that deal, and a couple years later, and so they are in year 18 right now, or maybe year 19. So year 15 has passed, and by the way, that year 18 or 19 is meaningful, and I'll get to that at a point later on. In any event, a lot of the red flags that were featured by the NHT people are present here. The investor limited partnership did change hands, and the current manager of the investor limited partner is one of the notorious aggregators. The investor, upon acquisition of their interest, started paying a lot of attention to financial statements and audits, and really taking some egregious action against the general partner. One in particular, I think, bears a little bit of note, and that is that several years ago, just prior to the expiration of the credit period, the general partner wanted to refinance the debt on the property in order to provide cash with which to pay the deferred development fee. And at the time, guidance among practitioners was that you needed to pay the deferred developer fee before the end of the credit period. Current guidance is more relaxed in that regard, and many practitioners will advise their clients that you can pay the deferred development fee before the end of the compliance period, which is an additional 5 years, but that was not the guidance at the time. And so the plan was to refinance the property and pay and use the cash to pay the deferred development fee. The investor refused to consent to the refinance, as was their right under the partnership agreement, and instead they insisted that the general partner make a cash contribution or make a capital contribution to the partnership for the purpose of paying the deferred development fee. And what that did is made the investors, made the general partner's equity piece, equity distribution, go much further down in the waterfall in terms of capital contribution or capital proceeds when and if the time would come. So that's part of the history. The partnership agreement provided for a number of buckets in the waterfall that would go to affiliates of the general partner because of investments that the general partner had made in the project, both prior to the tax credit partnership and after the tax credit partnership had been entered into. And so the expectation, both at the closing of the partnership deal and all along, was that there would really never be a residual available for the purpose of distribution to the investor limited partner. So after year 15, the general partner sought to buy out the limited partner, and there was a structural problem in the partnership that made it somewhat more difficult than in perhaps other cases, and that is that there was a put provision that favored the investor, but there wasn't a corresponding call provision that could be invoked by the general partner. And so the idea was to go ahead and persuade the investor that there's no residual there for the investor, and therefore it's really of little use to the investor to stay in the deal. The general partner talked with the lender, got a preliminary commitment based on the lender's evaluation of the fair market value of the property to do a refinance loan, and they would use the proceeds to buy out the investor. They would not try to bring in a new investor because they were perfectly happy to leave their equity in the deal and continue on. The investor refused, and not only did they refuse, they exercised their put right because they disagreed with the general partner on the fair market value of the property upon which the whole offer had been based. Well, it turned out they were right. The fair market value was a good bit higher than was anticipated by the general partner and by the lender. And so there was going to be a residual. But the bonus to the general partner was that, well, if there was going to be a residual, that means that all of their buckets got filled up too. And so they were going to be able to take out some cash if they were able to do a deal that would it would provide that fair market value to the general partner and to the investor. A couple of complications. One is the general partner simply was not willing to give up control of the property. They would not sell. They had a long history with the property and a long history in the District of Columbia and the region in doing affordable housing deals, and this was not going to fly. So they were able to arrange with a replacement investor to make an investment in the property to buy out, the proceeds of which would be used to buy out the investor, the existing investor, and that's how they structured the deal. The one thing I want to mention is that this is somewhat unusual in that negotiations were during the pandemic, and there had been a huge run-up in residential property values as a result, and so that's one reason that the value was there to enable the transaction to be negotiated. Another thing that makes a DC deal in general, and this deal as well, somewhat unique, is that there really wasn't an opportunity for a qualified contract to be sought in order to try to terminate the extended use period. And a reason for that, at least in this case, is that if you do terminate the extended use period, you can't bring it up to market, certainly not quickly, because DC rent control applies to quite a lot of the properties that are financed with tax credits, and this is one of them. So rent control it kind of sits in the background when you have a tax credit partnership or tax credit agreement in place, but it is there to be reasserted as soon as you come out of the aegis of the regulatory agreement. Another thing unique to DC is that there is something called the Tenant Opportunity to Purchase Act, TOPA. So the parties had in mind this as well. And again, I mentioned that we're in year 18. There is an exemption for TOPA that exempts transactions such as this, which is basically replacing a tax credit investor. But it only is available if there are at least 10 years remaining in the extended use agreement for the property. And in this case, we now have 12 years remaining, something less than 12 years remaining in the extended use period. And so therefore, the general partner did not want to litigate the issue with the investor, because as we all know, litigation takes a lot of time and a lot of money, and they were not prepared to risk not qualifying for the exemption, because again, they were adamant that they wanted to remain in the role of general partner in the deal. So the deal hasn't closed because in order to take advantage of the exemption from TOPA, we were required to and did give a notice to the tenants that the deal was imminent, and the tenants organized and decided to challenge the use of the exemption. And so there we are. I'm done.
All right, thanks, Hank. I'm going to share a couple more examples, one in DC, one in Virginia, to try to hit high level. I think each of these kind of exemplify some of the common features that we see in these disputes. So let me start with the DC one. This was a 100% Section 8 property in a strong neighborhood, a strong real estate market. So I think this is kind of a classic type of property. Section 8 equals strong cash flow typically, not always, but typically. And that was the case here. So a property with a lot of value. And those are the types of ones that where investors often pay greater attention to what's happening at year 15 and see if there's a way that they can share in some of that value, participate in some of that value. So the nonprofit held a right of first refusal. There was one quirky element to it that I'll talk about in a minute. But sort of as is often the case, rather than going through solicitation of offers that would trigger the ROFR and providing notice, et cetera, they approached the investor and said, hey, we're at year 15. Let's start talking about the exit here. And I think that's in general, a quite customary and appropriate way to handle things, or sort of an expectation that the parties are going to happily part ways at the end of year 15. The ROFR had a typical debt plus exit taxes purchase price. The investor had a positive capital account, so there actually would have been no exit taxes owed in this situation. The one unfavorable piece, if you will, was that the nonprofit sponsor wanted to structure the exit as a purchase of the investor's interest rather than a purchase of the property. And the statutory ROFR is designed as a property purchase, and there's various reasons why you might want to acquire the investor's interest instead, looking ahead to what's going to happen next with the property, including, for example, TOPA-related issues, as Hank was alluding to in the district. And in those conversations, the investor made it clear that they weren't simply going to walk away for nothing, even if under a true ROFR exercise, they might not be contractually entitled to anything. And again, as is often the case in these conversations, it wasn't so much direct threats as more subtle comments and statements. And at the end of the day, in the interest of moving things forward, the nonprofit agreed to pay an exit price of around $1 million, made possible by the fact that this is a financially well-performing property and the refinance could support that. But going back to our earlier points, just because it could be done, that's $1 million that could have been spent on resident services, or it's an extra $1 million that needs to come from the DHCD Housing Production Trust Fund ultimately to make the project work. That could have instead been lent to another project with weaker financials. So even though it was doable here in the big picture, it's a slow and steady erosion of the larger public policy goals here that are being served by these projects. The other interesting wrinkle here was that the general partner, the nonprofit was co-general partners with a for-profit. The nonprofit held kind of this customary right of first refusal, but there was a separate negotiated feature with the for-profit partner that required the nonprofit to buy them out at fair market value for their interest. And I kind of raised that only because, as I touched on previously in terms of the DC QAP, which now dictates the ROFR price quite specifically, there's an interesting question whether those types of arrangements would be permissible. Arguably this one was structured in a way that it wasn't technically part of the ROFR price. It was in a different aspect of the partnership agreements that were part of the ownership structure, but it will be interesting to see how the new QAP language impacts deals that are going for those nonprofit participation points, where there might also be a for-profit general partner or sponsor involved in the transaction. The second case is probably even more classic in a sense. Here, the nonprofit received an offer to purchase. They provided the investor notice that they intended to exercise their ROFR. The way that the ROFR had been drafted required both a notice to the investor, but also the investor's consent to the calculation of the purchase price. So the nonprofit, sent the notice saying, here's how we calculate the price. Please confirm, and we look forward to closing promptly. The response they got instead was, we don't think that the offer that you received was a bona fide offer, which was the terminology required under the ROFR. We have the right to consent to any sale under the partnership agreement. And in addition, there were, insinuation of breach of fiduciary duty, as Bobby talked about. So these are kind of the elements that the DCQAP also tries to get at, right? Whether there's consent to the sale, sort of broader consent rights, whether there's the need for a bona fide offer to trigger the purchase rights or not. In particular, and also this element of the accountant determining the purchase price, so you don't have to go to the investor for that approval. So, this exemplifies why those features are important to kind of minimize the investor's role to the greatest extent possible and what they can say, objections they can raise. At the moment, the nonprofit, when it became apparent the investor was not going to cooperate, brought an affirmative suit to try to establish their right to purchase, and litigation is ongoing. So I know we've run a bit long in our presentation, so we can have a little bit of time for Q&A. So
yeah, thanks, Aaron, and thanks, Hank. I think all three of those cases are really valuable. Like I just said in the chat, we might end up going a few minutes after 1 o'clock. Want to be conscious of everyone's time. But what I will just say before anyone needs to jump off at 1 p.m. is thank you to you all for joining. I will say our email addresses are here on the slide. So if anyone does have any questions that we weren't able to answer today, or has any other questions and wants to reach out, please don't hesitate to let any of us know. And there are a few questions in the chat, which I think might be best answered by my panelists. But I can start with the first one. Brian wrote, can an HFA require review of an LP interest transfer if its approval was not required as part of the original deal 15+ years ago? And would this solve current problems, or is this a solution for mostly future problems? So Bobby, I think you might be well positioned to answer that one.
Yeah, I think that's a good question. I would say probably not. But if you are a credit allocator and you have subsidies to hand out and you want to hand them out to entities that are supportive of the affordable housing mission in the state, I think that gives you a lot of leverage to encourage that even if you don't have the right to do it, I think it gives you the ability to at least encourage it. But there may be other elements that give the allocator, the credit allocator, some control over the property if there's a loan on the deal, or depending on the language of the regulatory agreement, they may have some greater power. But just imposing that on existing deals, I think that might be problematic.
In the District of Columbia, typical, and if you're doing a bond deal with tax credit, with 4% tax credits coming along with it, every time you refinance, you're required to get an opinion of bond counsel, which could be leveraged at least to some effect. It's not a direct approval of this particular situation, but nevertheless, it is often the case that that their debt financing is being sought in connection with these deals. And to replace the debt, you're often required to get an opinion of bond counsel for that purpose. So.
So another question, so Robert's asking, is there a mechanism for various state HFAs to share information about LP investors that have undertaken actions that would undermine the long-term affordability in LIHTC properties? And I will just start by saying, I think a lot of state HFAs are kind of hesitant to have a formal list of names of organizations to track. And I think similarly, what we saw even in DC was this hesitation to have this list of here's a list of bad actors. And I think it's also difficult to keep track of the names of those organizations as well. I think as Bobby alluded to earlier, a lot of these organizations and aggregators often get acquired by other different private equity firms. They might change their names. So I think that it's also hard for, I mean, even a nonprofit developer, you know, if you have any language in your partnership agreements that say that you can't, your investor cannot sell its partnership interests to one of these bad actors, even having a list of those in your partnership agreement, you know, if you have a list of the names, that might be relevant for the next 5-10 years, but you know, we don't know what those names of organizations or new organizations are going to look like in the coming years. Anyone else want to add anything else to that?
So, you know, a list of names, particularly in a partnership agreement or in a, well, I guess in a partnership agreement, as you say, Mohad, could have limited application years hence. So whether you are a state or a general or a developer, what you also want to include is a criteria or a standard for review of who the transfer is to and what kind of activities they've been engaging in. Some states are requiring a attestation by the credit applicant and the putative investor that they have not done such and such and such and such. So it is hard to keep track of all of these entities and as they change and merge, but there are ways around it to deal with it. Maybe perhaps not completely effective, but somewhat effective. And we're certainly sharing information. We have a list of the 40+ cases in litigation, which is a pretty good indication of who the parties are and who you should not invite to do business in your state.
Thanks, Bobby. Again, I do want to be conscious of everyone's time, and at least by my clock, it is 1:05. So I guess I want to just take this opportunity again to thank my fellow panelists for joining me today. I do know that we shared a lot of information over the last hour and 5 minutes. So again, please don't hesitate to reach out to any of us with any of the questions. I know there were a few that we weren't able to answer. Also want to thank CNHED, of course, for hosting us and for their partnership in advocacy in these efforts in DC. So Scott, I'm not sure if there are any other final remarks that you want to share, but thank you for this opportunity.
Oh, sure. Just wanted to thank Moha and Bobby and Hank and Aaron for sharing their time and their experiences to bring people up to date with what's going on and to bring this conversation about these problems to more people. We encourage everyone to use the emails that were in the presentation and the slide deck that you saw to reach out if you are having one of these problems or anticipating having one of them, so you can learn more and try to avoid some of the worst circumstances. And we will be sending out a recording of the webinar as well as a copy of the slide deck to everyone who registered for the event, as per usual with CNHED events. So thank you all for spending part of your afternoon with us and for going a little overtime with us. We hope you all have a great rest of your day.
Thanks, bye-bye.